Whether you're trademarking your mom's secret cookie recipe to copywriting your cat's Instagram photos, we've got you covered. Because today, we're joined by the world-famous Mike Colson of Redirect to talk about IP considerations that every startup owner should think of. This is Stuff You Should Know About IP. If you enjoyed listening to us muse about IP and watching the random outputs of ChatGPT read aloud by humans on a Teams recording, then don't forget to click the like button, share with a colleague, and leave a comment wherever you're listening. Today's episode of Stuff You Should Know About IP is brought to you by the Patent Lawyer magazine. If you want to stay up to date with everything that's going on in the world of IP and patents, go to www.patentlawyermagazine.com. Each issue is free to read for up to 8 weeks. That's www.patentlawyermagazine.com for global news in the world of patents. Okay, Tom, Mike, we're back. I just got to say, we took a long hiatus from this podcast. It's been like almost a year. And if you can believe it, we're 4 years into doing this podcast. And it blows my mind when I look at the millions of views that we get, that this many people are interested in IP, but they're going to be especially interested in today's topic because we got Mike with us.
Yeah, and what I hear is it took us 4 years to get Mike Colson to agree to join us.
Yeah.
So
I think we were at that dinner party at his house and we saw the beautiful invitation that we had printed and it was still in the envelope. It was like sitting
right.
like under a pile of like coupons.
It was dated 2021. Yes, exactly. But finally we got Mike. And Mike is a kind of like an IP-ish person, right? Because he has a brother who's a patent lawyer. But before we get into Mike's business, let me just say that Mike and I have been together for like 50-something years, right? You know, that's how brothers are. And Mike has known that I'm a patent lawyer for at least, 25, 30 years now. And Mike has become a serial entrepreneur, and he's really bright too, like super smart guy, PhD, savvy business leader, but still, he makes IP mistakes. And as you know, Ray, I teach at a school in Lausanne, Switzerland once a year, and I always goof on a couple Mike Colson stories behind his back. So it's good that we could do it face to face now because they're fantastic learning experiences. And I mean that sincerely. You make a mistake with IP and you never make it again. And Mike has made a few. I've made a few. I mean, I've made a few massive goofs and I'm an IP guy. So we wanted today to talk to Mike about his newest startup business and the types of things that you need to think about in connection with intellectual property. So, Mike, what do you do?
All right. So we have a phone app business. We have a phone app business that what essentially does on the App Store is you can download from the App Store. It's called Redirect, REDYRECT. So we put a Y instead of the I. We'll get to that in a second. The way this all came out was I was talking to my brother Tom, and he used to be in court and so forth when he did things in court, and he'd have very important clients wanting to talk to him and contact him, but he's in court, he can't deal with it, or he's in conference in some way. And one of the things that came out of it was he says, if I had known this person was calling, I would have answered it. I said, well, I just look at the phone, the caller IDs. It's because they call from different numbers. I don't have them in my number, whatever it would be. I don't have them there. So what we did was we came up with this concept of VIP calling. So what it does, it sets up a kind of an emergency access for your VIP for VIPs that lets them reach you from any phone at any time with we'll talk a little bit about this, our patent pending call breakthrough technology that allows you to be able to say, Mike's calling, and Tom can answer the phone or decide not to. But if I'm a VIP, I get that. There's applications of this for lawyers, but there's also applications for a dentist that does oral surgery. One of the clients now, he says, look, I want people to be able to call me with problems for 3 days after surgery, but not after that. So I want to be able to block them, to only have the VIP code work for a certain period of time, or and that's kind of the path of what we did. But one of the things that we did, which I thought was one of the first things I probably got very interested in, was I said there's the letter Y, so I do redirect with a Y, and the reason why is because number one, we wanted to get a .com, and I was talking to Tom, and he said, "Mike, have you trademarked that yet?" And I said, "No, I haven't trademarked it." So I said, "But I do own the .com." He says, "Mike, that's not enough. You got to think about trademarking too." So then Tom and I started talking about trademarking.
Yeah, and why would you think of that, right? Because it's not that you're related to a patent, copyright, and trademark lawyer, right?
Yeah, exactly. And our issue, yeah, because the problem we have is that I'm trying to start up these businesses, and I have so many things to think about, and so I have so many things to think about, and frankly, they're not IP. But one of the things that Tom said too, and he's right about this, is he says, "Look, Mike, if you don't protect your intellectual property, especially in the technology you're talking about, um, your business isn't worth anything." And I said, "Tom, you know how many people have told me that if I don't do something, my business isn't worth anything?" And he started explaining it though, and I'm realizing I think he's right. Because if I don't patent this, if I don't trademark what I have, it's he says it's kind of Tom told me, he says it's akin to getting the .com, If you don't have the .com, Mike, how are you going to run an internet business? I'm like, look, I understand that, but I didn't understand the point about IP.
Yeah, because the big thing with you, Mike, and every startup out there is you're outgunned at every turn by big companies, right? You have in your possession an ability to prevent big companies from copying you if you take advantage of those tools. And if you don't take advantage of them, you and I talked the other day, you have a fantastic application that if you succeed, every phone company, and I'm probably saying the word wrong, but every big company out there that's in your industry will steal your idea. They will do it without you, and you will be left behind because that's your only differentiator, right?
Right, because you can't. Here's the thing: is that and I work with companies all the time that I've owned several of them, and these companies, the guys that they all come to me and say, "We've got our software, our connection to the hardware. This is unique, and we're super smart." Is what people will say to me all the time, and I'm like, "Yeah, I know, but you can't really corner the market on smart." Right? Because what's going to happen is that your one smart idea, you got one smart guy there, and they've got a whole floor. Tom used to tell me that too. He says, "Mike, they got a whole floor of people just as smart as your guy is down at AT&T or at Verizon or wherever they are or whatever I'm doing. They've got a whole floor of those people. So you can't protect it by just being smart." And then people will also, but Tom, one other comment I'll say is that the other thing they say is, "Yeah, but we're out there first." I'm like, and I would tell them, and I kind of work with my people too and say, "Yeah, we could have first mover advantage, and that is important. But we're small, we're a little guy. If we can't rapidly scale to a huge size, the probability of that is almost zero. If we can't rapidly scale to a huge size, somebody's going to come in and they're going to steal our bread, take it out of our own rice bowl."
Yeah, it's very rare, in my view, that a small company can take advantage of first mover status without intellectual property protection. Because, yeah, it happens. But most companies, as soon as their idea is out there, everyone will copy it, and they've lost their advantage because they're so small. So you and I have talked about, like, what do you need as a startup company? What do you need to be thinking about? And, remember that one situation we had a few years ago with that one guy who was building software for you? And you came to me and said, "Hey, can we get patent protection on this?" And my first question is always, who invented it? Right? And okay. And then it's, well, this guy invented it. And I said, okay, do you have an agreement in place? Because I always want to see the documents, right? Because if you don't have assignment agreements in place, they typically own the intellectual property. And in that particular case, Mike, you had a friend doing some development with you. He did not sign an assignment agreement because your attitude was, why should I? He's a friend of mine. He's not going to, he's not going to do anything to harm us. But then when you tried to get the assignment agreement signed, it was stickier it was more difficult than you thought.
It was.
So,
Sure.
so the first thing I always tell people is you're going to have employees and contractors, and you must have agreements in place with them that assign intellectual property rights and the rights to all the underlying work product to you. Because without that, in most parts of the world, the law is the person who invents it, the person who creates it, is the owner unless there's an agreement that says otherwise. And these agreements shouldn't be oral, right? They got to be in
Sure.
writing. You need to be able to prove it. So my first step, whenever we have a conversation, I always say, in fact, I said it with Redirect, with your new company, Mike, do you have agreements in place with your employees? I always ask you that question.
Sure, you do. And the other thing we talk about too, though, is how you establish consideration for that agreement, because sometimes you're not paying them initially in something, right?
But you're giving them something, and that could be equity.
You're giving them stock,
right?
You're giving them equity,
Yeah.
or you're giving them the promise to pay something in the future. You're giving something for that. And that's what you always told me is make sure you give them some consideration. So there's some
Yeah,
consideration.
and don't just go to like LegalZoom to get an agreement, because you need to be counseled by someone who does this because of what you just said. Most people don't even know what consideration is, right?
Right. Yeah.
So you need to talk to somebody who actually knows what they're doing. So that's an agreement, which is an assignment agreement, right? With your employees, with your contractors. But there's another agreement that you should be thinking about, which we've talked about, which is called a joint development agreement, or JDA. Because you might be developing something with a partner, right? And they have needs and you have needs. You both want to own all the intellectual property if you're savvy enough to think about it. So a joint development agreement is something you put in place to ensure that you each understand who's going to own the rights to what, that you bring into the equation, that you create during the relationship, or that you create after the relationship. Those things have to be defined. And we've done that together, right, Mike?
Sure, we have. We've done a few of those, and that is it. Sometimes it's easy, and sometimes it's a sticky discussion in terms of having that. But one of the things, though, that, as I said, is you come back to is to say, how do you be reasonable on the agreements you're trying to pay lawyers to put together for you, and how do you not? Because you can spend unlimited amounts of money, the capital that you have, protecting something in a very comprehensive way where you can get all the protection you really need for less money sometimes, more money other times.
Right. But agreements, no matter how complicated an agreement is, it's much less complicated and less expensive if you deal with it up front versus downstream when you're fighting about ownership, right?
Without
And
any
you're
doubt.
litigating.
Without any doubt, it's cheaper.
Right.
I'm just trying to be a reasonable startup guy.
Yeah. So while we're on the subject of contracts, the other contract to think about is called a non-disclosure agreement. Now, those should be done with your contractors, with your employees, and also with any partners that you get involved with. But the key thing to remember about the non-disclosure agreement, or NDA, is they do not prevent unlawful disclosures of your information. They only deter unlawful disclosures of your information, which means if you're dealing with an untrustworthy, sleazy party, an NDA really won't do anything, because once your secrets are out there, yes, you might have a cause of action against this sleazy perpetrator, but your information is out there and you can't put it back in the bottle, right? So you have NDAs, right, Mike?
Right. Yeah, but there's another part to the NDAs that you and I have discussed too, which is that just because you say the information is confidential, you have to actually notify them what information is confidential.
Yes.
And that's something a lot of people miss. Everybody signs the NDA and then they just move right on, and they don't follow up the meetings. They talk about everything, but they don't follow up. And Tom, you used to tell me this too: is you follow up the meeting with, we talked about this, and this, and this is confidential. Or you send over a PowerPoint and say, you stamp it, you say confidential. Because other than that, most NDAs say you have to notify us of what's confidential.
And hey, remember that guy, Don Davis? Remember my mentor, Don Davis? May he rest in peace. The way I met him was he was on the opposite side of a negotiation, and he would send me an email after every meeting that listed everything that was discussed as if he created it. And that compelled me to send a note back every time saying, wait a second, Yes, that was discussed, but you didn't bring it in. I'm the one that brought it in. And he would always say, hey, I'm just saying what was discussed. But that's not what he was saying. He was establishing his territory, and it was really smart for him to do that. And Ray and I have dealt with a situation where this is really cool. Ray invented this, I think. So we dealt with a company because a lot of times big companies will not agree to put things in writing that are confidential. They'll say, oh, we want oral disclosures covered as well, which is completely crazy, right? How do you prove an oral disclosure? So
Sure.
Ray came up with a brilliant idea, which is, I got an idea. Every time we meet with them, let's just send them an email that says, we agree that nothing was disclosed today that's confidential. That puts the burden on them to
On
say, oh, well,
them.
wait a second. Yes, we disclosed this. So we're indirectly forcing them to put it in writing, even though they didn't want to. Because if
It's a good
they
idea.
don't, if we ever get sued, we say, hey, we sent you an email that said nothing was disclosed. Why didn't you respond? You know what I mean? So anyway,
I do.
so that's the NDA thing. And you got to be thinking about NDAs because your confidential information, once it's gone, it's gone. And that brings me to the next thing, which all new companies should have, which is a mentality of trade secrets. I'm not saying everything should be a trade secret, but I am saying everything should be treated as a trade secret until you affirmatively decide otherwise. Because you can't go back to a trade secret. You can't say, oh, well, let's publish this, then decide later to be a trade secret. Start with everything being totally kept within the circle of trust. You know, that was a movie. I can't remember what it was called. I think it was Meet the Fockers. But anyway, keep it within your circle of trust, right? Then when you decide to make it a patent or make it a publication or just put it out to the world, that's okay. But at least you know you're keeping it protected until you've decided otherwise, which brings me to the next thing, which is how do you decide what you're going to do with it? I mean, Mike, you always call me, right?
I do.
But every company needs someone like me. And I'm not bragging, but I'm an IP guy, right? So you need something called an invention review committee. Essentially, what do you think they do? They review inventions to decide what to do with them because you could get a patent. You could keep it as a trade secret. You could make a defensive publication. You could just say, we're not going to do anything with it because it's not worth protecting. But all those decisions are made affirmatively with an invention review committee, and they typically consider stuff like what's the commercial value? And Mike, you and I talked about that. We just filed a patent application like what, 3 days ago or something?
Yeah, sure. Well, and that was an interesting discussion because what we were, just to give a little bit of background, we had been building this technology for almost a year, spent a lot of money on the technology, and some of the advantages that we thought we would have in it are there. But we thought to ourselves, okay, I always thought, and we started to, we were just at the verge of sending it out for testing to a testing group of people that, by the way, we did, they were just our friends because, you have to test an application.
Your son.
See, and it's a consumer application. My son, some other people, about 5 or 6 or 7 people that we wanted to send it to just to start to test it. And Tom and I were talking. He says, Mike, stop. And I'm saying, what do you mean stop? I mean, yeah, why do you even stop? I'm not going to stop. I've got all this money invested in this thing. And he says, if you don't take a look at it from an IP standpoint, you could burn all your rights. And I said, no, Tom, no, you are wrong here. I said, I have 1 year. You told me this. I have 1 year from the time that I start to put this out there to file a patent. And you said, Mike, let me tell you something.
That's the U.S.
Do you want to use this in Europe? Yeah. I said, do you want to use this in Europe? Do you want to use this in Europe and all the other PCT, patent cooperation treaty countries? He says, they're different rules. You got to follow those. And I'm like, oh, geez, what do I have to do? Well, talk about that, Tom.
No, you stopped it. Like you said, well, I already sent out links for the beta to like 15 people. And then we talked to your partner. He goes, oh, I could shut those off right now. And I went, shut them off right now.
Yeah, we had a meeting. Right, shut them. It wasn't even we had a meeting. He was there and he said, shut them off. I got the guy. The guy was sitting there and he says, okay, they're off. And my phone starts ringing. People say, why can't I get on? Right.
Well, the funny thing is you wanted to do what everybody wants to do in business, which is get to market, right?
Yeah.
I wanted to get to market too because I wear 2 hats. I run a business and I'm a lawyer. But I also want to get to market by not burning rights. So what I said to you, Mike, is Normally takes us like 5 weeks to get a patent application drafted.
Yeah.
What we will do for you is get it done in 2 weeks. Can you hold off for 2
By the way,
weeks?
Tom, so we're clear, it was 9 business days.
Yes, 9 business days. We got that thing drafted and filed, and it was beautiful, right?
32 claims, 32
Yeah,
claims in it. I
and
mean,
it
this was
really
not trivial.
well written. Yeah. So, and by the way, I didn't write it. One of my guys wrote it. But the point is, you waited 9 days, before you went to market. Now we have a patent application filed, and now you can fearlessly go into the marketplace, talk to people, you do betas, speak at a conference, speak on this podcast, right? Because you've got your priority date set, you've got your patent application filed. You won't burn your rights now. And now,
but one other thing, Tom, came up with this too, and that was we sat there and we came up with other ideas that we had not we would have not have gone through in such a rigorous way. We came up with other ideas, and we're going to file another patent before, and we're not putting out those ideas haven't been codified yet. They're not put out there.
And that brings me to the next thing.
Because of the process. Because of the process.
Yeah. That's the next part that a startup thing, your startup entity needs to think about is what we call invention harvesting, right? And there's 2 kind of things: invention harvesting and ideation. Invention harvesting is essentially extracting embedded ideas that are already in the brains of your people to get those out for patent applications. And we spent some time doing that with my guys and your guys got together. We extracted more ideas that you've already been thinking about, but we're not going to make it into the 1.0 version of your product. So now we're getting ready to file patent applications on those before you go out with your 2.0 version of the product. And by the way, the other thing is called ideation, which is really, okay, now we want to provoke you to think about new applications or new features and functions that you might think about for downstream applications. And that's what we're going to do next. We haven't done that yet. We did the harvesting last week. We're going to do the ideation in the next few weeks. But there's another thing a startup needs to think about is where you're going, because the moment you get out into the marketplace and people like your stuff, they're going to want to steal it because no one wants to pay you licensing fees, right? And they're going to want to improve upon it, right? And it's so much easier to improve upon something than create the initial idea. If you're starting with a blank canvas, it's challenging. But if you're improving on it, it's less challenging. So we need to get patent applications on those as well, right?
Yeah, and I do. But the other thing that we talked about, which I thought was really interesting, is to say, okay, one of the things that you brought up was, okay, we've got this one patent filed. It might be advantageous to us to look in the marketplace for other patents and to be able to create a patent portfolio that then creates an asset value all to itself. Maybe you want to talk about what we did or what we're talking about. We haven't done it yet. We haven't done it yet.
And that's the next item on my list about startups, which is perfect. You said to me, hey, Tom, okay, we have one patent application filed. We have a few other in queue that we want to get filed, but we want to build a more robust patent portfolio sooner, because what does a startup want to do? They might want to explode into the marketplace and grow like crazy. They might want to explode into the marketplace a little bit and get purchased, right? Or get third-party investment so that they could grow more rapidly. In any of those scenarios, you need more patents, right? So how do you get those? Well, you can ideate, you can harvest, or you could buy stuff that's already been patented. And that's what we talked about doing, is doing what we call a landscape search, which basically finds all the related patents that are out there. Then we'll look at them and see which ones are any good. There's some patents that they call picture patents, which are basically, they're not even worthwhile. They're just good for your wall because they're so narrow. The claims have so many elements that it's easy to get around them, right? So we would look and see which ones have really good claims, and then we could go and approach that person for either a purchase of the patent or an exclusive license to the patent. And basically, if you have an exclusive license, it's almost like owning it, because no one else can do it. So you're right. The next thing on our list is, after harvesting and ideation discussions, should we buy something? And depends upon what your resources are.
Right, but also I think what you said too was that there's a lot of single patent A single people that only have one patent, and
Yeah.
that's all they've got. One patent. They don't have a business
like
around
you.
it. They have nothing. Yeah, like us, right? Or like me, right? No, but they have just one patent, and they don't even have a business around it. They just,
Right.
it came out of a university, it came out of whatever. They have it on their wall, but it's also a valuable patent, but nobody's using it. And those
Right.
things, I think you explained to me, we might be able to cut good deals for those people and get them a little something they weren't going to get. It was just going to run out all their patent time anyway, and we might be able to good deal for them, and we get a very valuable thing on our side, which is another patent to put out there.
Yeah, which your portfolio then does a few things. Number one, keeps people from copying your features and functions, which is huge for a startup because that's all you've really got. You need a prevention tool. You need a legal way to keep people from copying you, keep big guys from copying you. The other thing it does is helps you get venture investments because they like a company that can keep people from copying them. Third, a big company might want to buy you, right? Wow, we love your app.
Sure.
We know we can't copy it. We want to buy you and all your patents to get that. And fourth, it could be a defensive tool. You might get sued for patent infringement at some time and do a cross-licensing deal to avoid what could be millions in litigation fees and damage awards.
Right, and I think your third item there was an important one because what we could do is create what some buyer might want is they say, look, you have an entirely packaged portfolio of all the patents in your space, and you own this little portion of the space. It's yours. You have a couple filed. You have a couple that are issued. You might even have one super patent in there somewhere. In there. And if you do, you're now in a spot where that's an asset. That's part of what somebody might want. So you go to the big company and they say, I've got a small group of customers using it. The technology works, and I've got 3 or 4 patents around it. It's a whole package.
What's that worth? Right. Yeah, exactly. Hey, so just to move this along, a couple other quick things I want to mention. In addition to having a trade secret mentality, startup companies need a trade secret infrastructure. Now, that leads me to IP education. So Ray and I run a company called Executive IP. As you might know, look at all the swag around Ray's office there. He's wearing it. It's behind him on that flag or that blanket. So anyway, we create corporate training videos to train people in companies to be thinking about this stuff, right? So part of an IP or a trade secret infrastructure is, of course, IT, right? It's technical, but part of it is cultural. It's your mentality. We need to know that we have to keep these things secret. We need to know what need to know means, right? So whether it's trade secrets, patents, trademarks, copyrights, defensive publications, licensing, any form of IP, your people need to understand what it is, not as patent lawyers, but just enough to know when you see an issue or an opportunity when you should call the IP professional. So there's a trade secret infrastructure and IP education. Ray.
I mean, this is the one thing that I can contribute the most to in this discussion. Yes. So I just want to say that IP strategies are decided by the most senior people in the business, the founders, the CEO, but they're executed by everyone. And any IP strategy is going to fail if all of your people aren't on board with it.
You are so right. Well said. So,
but also I think to make them accessible, Tom, too, though, the accessibility is important. And one of the things I've seen your videos, and what's cool about them is they're very accessible because patent technology, patenting can be a very arcane process.
Boring.
So the important thing is boring. But I think what's kind of cool is you guys have gone down the path of being able to make a series of videos that slowly bring a person into that without being too burdensome, and also not working them all up with all this arcane knowledge and saying, this is what you have to do to get where you need to go. That's what I think.
Everybody hates corporate training, if we're just being honest. Sorry to all the HR folks out there. And when you take a legal topic like IP, obviously that just makes the situation worse. So it has to be presented in a way that's interesting for people. And that's one of the reasons why we do this podcast as well.
Yeah, and by the way, if anybody wants to get IP training, Ray is the guy you'll be talking to because he knows more about it than almost anyone on earth in terms of IP training, right, Ray? You know how to deliver it. You know how to create it. You know how to sell it. You know everything about IP training, which is reason number 20 why I'm so thrilled to be working with you.
All right, so moving on from the same shameless self-promotion, Tom, we didn't really talk much about trademarks yet.
Yeah,
Do you have that on your list?
That's a good one. Yeah. Let me do that really quick. Trademarks. Everybody always comes to me and says, I want to register my trademark. Well, here's the thing. The first thing you need to be doing is start using it. In most countries, not all countries, most countries have something called common law trademark rights. In fact, in the US, your rights really flow more from usage than registration. If you don't use it in the marketplace, you can't even get a trademark. So what I always tell people is, first step in that is start putting a TM next to the trademark use whenever you do it, in brochures and, on your website, wherever you use on your product, put a little TM, because now you're telling the world, hey, I don't have a formal registration, but I'm using this as a trademark, so beware and don't copy me. And that's a common law trademark, and they're really useful. Even if you want to get a registration, you have to start by using it. So I told you, Mike, that start using it. And here's what I love about your redirect mark, Mike. Arguably, so there's like several layers of trademark significance, and you can't get a trademark on something that's descriptive, purely descriptive, right? And yours is called redirect, right? Which might be descriptive. It might be suggestive, which is okay. Suggestive is above the line. That's good. Descriptive is below the line. That's bad, right? And the reason you can't get descriptive marks is the world doesn't want to take descriptive words out of the competitive environment, right? Like if I have a lawn service, I don't want to call it lawn service, because then no one else can use lawn service for their lawn service, right? So if it's above the line, though, it's just suggestive. If it's merely suggestive but not descriptive, you're okay. Redirect, I don't know if it's above or below the line in terms of what you do, but you change the spelling of it for two reasons. One, to get the domain name. You put the Y in there, REDYRECT, instead of REDIRECT. Redirect as a word might be descriptive. I don't know. But redirect with the Y, it's like a stylistic mark. You have a much better chance for trademark protection, and you could get the .com, which you would have never gotten for less than $500,000 for just the word redirect, right?
Right, so, it's true.
Trademark. The key thing, though, is use. Start using it immediately as a trademark. And
hey,
the other
by
thing
the way,
I wanted to mention,
I want to make sure we hit on one, is that people misunderstand copyright often, and they don't. I think you once told me that that by typing something yourself, it's copywriting as you're typing. Is that right or no?
Yeah. It's different. Now, keep in mind, every country has their own patent, copyright, trademark, trade secret laws, but copyright laws in the U.S. in particular, you have copyright rights as soon as you create the copyrighted material. That could be written, visual, audio. It's basically the written, visual, or audio embodiment of your ideas, right? If you have a technical specification, if you get a copyright, you don't protect yourself from people copying and building what you've described technically, like you build a robot. The technical spec, the copyright on your specification only protects copying of the specification itself, not building the robot. Patents protect the robot, building the robot.
Do I have to write Do I have to write the word copyright at the bottom of the document or no?
Yeah, you can write copyright, or you can file it with the Copyright Office at whatever part of the world you're in, and then put a circle C. So that would be copyright protection. Now, here's the one thing to remember about copyrights. Just because you can copy something on the web, it doesn't mean you have the legal right to do so. And if you copy images, there's companies, I think Getty Images is still out there. They chase you down fiercely if you copy any of their images and put it on their website. And I know people who have been, hit by these lawsuits. So you have to be careful about, just because it's available to you on the web to copy, it doesn't mean you are legally allowed to, and you could get yourself into trouble. Thing to think about with respect to patents, trademarks in particular. When you are getting ready to go to market with a product, you might not have any patents, but other people do. And you want to make sure that they don't sue you for patent infringement when you get out there, right? It's ugly. It's expensive. It might be, you have to calculate it in terms of hundreds of thousands. If we're in the US, it's hundreds of thousands of US dollars and millions to defend yourself. So there's a thing called a freedom to operate search. And basically, you hire a patent professional to search the patents out there in the world to make sure that you are not infringing any of them the moment you get into the marketplace. And the same thing applies to trademarks. They call them trademark clearance searches. Do a trademark search, which is both registered and common law in whatever nation you're going into, to make sure that when you come out with redirect with a Y, you're not infringing somebody else's trademark. So that's really what we call freedom to operate. Ray.
So just to be clear, if someone else was using redirect as a trademark for something totally different, such that Mike's use would not create confusion on the part of the consumer, then it wouldn't be trademark infringement. Can you explain how that works a little bit more?
Yeah, you are absolutely right.
Because
so
a lot of small business and startups, they don't realize this. They think, like, oh, I can't use Ford for my lawn cutting service when they might be able to, right? That's a bad example, but you get what I mean.
Right. By the way, the only reason that's a bad example is because Ford is considered a famous mark. Right. And famous marks have more protection than regular marks. So ignore that for a moment. Or let's just ignore it altogether. But you have a really good point, though. Mike could have redirect. There might be a company out there that's redirect for like a new pizza service, right? They redirect you to the pineapple pizza, or there's a system that they use they call their pizza place redirect. So they have a trademark, a federal trademark in the U.S. for redirect, and with a Y, by the way, because they were also wanted to get something stylistic. Then Mike comes out with redirect for his phone app, essentially, right? Because they're different, and it wouldn't confuse the public. No one would think that this redirect pizza company is going to get into the phone app business. There's no likelihood of confusion in the marketplace. So Mike and the other redirect could peacefully coexist, and nobody sues anybody. And even if they do, nobody would win because they're not confusingly similar. The words are confusingly similar, but the industries that they're in, there's no chance that you jump from one to the other. It's just not reasonable, so no one would be confused. You're right. So basically, on that note, there's one other thing to think about before we wrap up, and that is a publication clearance system. This is slightly sophisticated for a startup, but it's also easier for a startup. So basically what it is this. You want to make sure that you don't burn patent rights with publications, but at the same time, you want to publish, right? You want to go to conferences. You want to spread the good news about redirect. You want to do what you almost did before you ran into me at Tim Hortons, which is get your information out there before you file a patent application. A publication clearance process is basically, you have to go through a specific committee before you can publish anything. You can't go to a conference. You can't do a journal article. You can't post on social media. You can't get beta users until you go through a publication clearance process. Now, it seems like it's too complicated for a startup, which it might be, only because it's hard to understand. But it's easier for a startup too, because you only have like 10 people, right? So you just tell everyone, hey, nobody publishes anything in any possible way till you talk to Mike Colson. And everyone will go, okay, solved, right? Now, you just wouldn't think of it because you're a small company, but now everybody watching this video will think of it.
Yes, exactly.
So that's your 30-minute overview of what you should do with IP if you're a startup company.
Thank you. If you've been listening to our dear audience, if you've been listening to this point and you have not yet clicked the like button wherever you're listening, what are you doing? Come on, this is stuff you should know about IP. It's the world's greatest podcast about intellectual property. Thank you so much for listening, and we'll see you on the next episode, which we promise will be less than a year from now. Bye, everyone.
See you later. Bye-bye. Bye-bye.